Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Intersentia. It's of course about the European Union, and the title is quite a long one. It's The Limits of Fundamental Rights Protection by the European Union, and it has a subtitle, The Scope for the Development of Positive Obligations, and it's been written by Malu Beijer, and I hope I've pronounced her name correctly. As I said, it's come to us from Intersentia Limited, who are based in Brussels and in Cambridge in the United Kingdom, and it's the School of Human Rights Research. Now, Elizabeth and I have discussed this book, and it's her basic review which I'm presenting. Its title we've given it is Protecting Fundamental Rights. Is the European Union up to it? Excuse me. And that's the title we've got. Let's have a look at the book first of all. There's the front cover. It's a paperback. There we go. There's the front cover there. Then there's the spine. And then you can see there's a little bit of information on the back, which basically explains the book. Now, it's very much the structure of all of the Intersentia books. It doesn't have that much of an index at the back. It does have the School of Human Rights Research publications listed right at the back, and you can see there are a regional number. This is actually the research series that they've got here. As I say, the index is very short, as you can see, and then after that you've got a bibliography, again at the back. The bibliography is fairly substantial, starting there. Now, the main book itself, let's go to the front page. That's the main front page there. And then you can see the basic information about Intersentia there. And then there's some detail about the author, which I'll mention in a few minutes. Then after that, you've got some acknowledgements. And then you've got the contents section. You can see fairly detailed as it runs over a few pages. There's chapters. There we go. It's split into 3 parts, and then you've got some abbreviations. I think the abbreviations are always extremely useful in these publications, purely and simply to just nudge you a bit if you've forgotten a particular abbreviation and what it may mean. Then you've got the table of cases there, starting with the European Court of Human Rights, and then after that various other specific case law which is actually referred to. You can see it there. Then we get to the basic chapters themselves. The first one, of course, being the introduction. You notice that there is some paragraph numbering, and you've got footnotes. So you've got all of the standard structure that you'd expect from each of these types of book. What I do like is the conclusions, which are developed at the end of each of the main chapters, which I think does help just bring the subject to a little bit of a conclusion, so you get some idea of exactly where one is going. You can see the 3 parts are structured and fairly detailed titles. So in fact, part 1 is the concept of positive obligations within the context of the European Convention on Human Rights, so very much the convention. Then the second is, part 2, is the scope for the development of positive obligations within the context of EU law, an analysis of the specific parameters of the EU legal order and the EU system of fundamental rights protection. And then finally, synthesis is part 3, right at the end. And as I say, it's an interesting book. It runs to something approaching 350 pages, just under. And it is, of course, a thesis as such, but it's been developed from the basic doctoral model. Now, what do we say about the book? We say this. It's a new title from the Cambridge and Antwerp-based publishing firm of Intersentia. And like many of their publications, this book will be of interest to comparative lawyers or those involved in cross-border matters, of which many of us are now despite or possibly because of the UK's imminent exit from the European in 2019. I'm recording this in the summer of 2017, and so we've got some way to go yet. Now, the author is Malu Beijer, and she's researcher and lecturer in European Union law at Radboud University in Nijmegan in the Netherlands, teaching in such areas as European Union fundamental rights law and EU judicial protection. And as she's worked with the Dutch government bodies and also at a Dutch law firm, she brings practical experience as well as a wide-ranging academic background to this prestigious research which she's undertaken for the book. The end result, of course, being her PhD thesis. Now, with commendable thoroughness and in carefully explained detail, Beijer has undertaken a step-by-step examination of what she describes as the concept of positive obligations, hence the subtitle. This concept, she explains, means that the states are required to protect fundamental rights by adopting a relevant and suitable legal framework aimed at ensuring that such rights are protected. Now, the European Court of Human Rights, she points out, has evolved a body of case law in this area and has asserted that positive obligations are necessary to ensure that fundamental rights are of practical value and effective for everyone. Now, that, of course, is a political problem for some people, certainly in the United Kingdom, but of course is not to be confused with the decision by the EU to leave the European Union itself, because the European Court of Human Rights is a separate organisation. It's important to stress that, because even people who've got some general knowledge of the way our relationship with Europe has developed sometimes misunderstand the court system concerning both human rights and, of course, the Court of Justice of the European Union, as it's now called. So let me get on to that. However, it appears, of course, that the Court of Justice of the EU, that's the CJEU, as it's now known, does protect fundamental rights and has nonetheless, and somewhat surprisingly, not developed the concept of positive obligations, which is quite interesting if one thinks about the model that you've got for European law itself. And now this is what she says. She says the question has been asked, she adds, as to whether such a development can indeed occur under EU law, and whether the EU has the competence to undertake regulatory action which will actively protect fundamental rights. These, then, are the key issues discussed and analysed in this volume, and that, I think, is the great benefit of it for anybody who's involved in this area. I think it's of general interest as well to anybody who's reading for a degree at the moment, because of the nature of what is happening within the EU with our departure. Let me go on. As so, with the will the concept of positive obligations ultimately achieve recognition under European Union law? And the book may well provide the answer, of course. This is what she says. In particular areas, the ECHR, the European Court of Human Rights, could consider being less deferential in the development of positive obligations, especially in cross-border situations. An interesting observation, I think, in its own right, because the Human Rights Court has actually created an awful lot of controversy in some member state countries over the type of ruling that it has produced. Now, as law and law firms of the larger variety continue to broaden the scope of their operations into the global arena, this book, we think, should attract considerable interest worldwide, as well as in the UK. However, when the UK does leave Europe, we will be out of the EU jurisdiction by definition, and subject no longer to any European Union court. At least that's the theory. Now, the Supreme Court of the United Kingdom will then become our final arbiter. And that, of course, is what the House of Lords was, which was its previous incarnation. Now, clearly, That again is a political judgment and a political issue for the future. But it would appear to me, certainly, and others, that with Brexit, that will be the case, that we will no longer be controlled by the Court of Justice of the European Union. And that seems to me to be an absolutely fundamental part of leaving the EU. But we shall see in 2019 what actually emerges. Let me conclude by saying that but what a useful acquisition this volume will be for academics, for international lawyers and students of European law who are seeking to familiarise themselves with the need for expert commentary on what is actually quite a complicated subject. And that's what you get with Beijer's book. Note, of course, that the book excels in its provision of research resources to be expected, including the extensive footnoting, the table of cases and the astoundingly lengthy bibliography. Definitely it's a book which will generate many a lively discussion, a much stimulating debate, and I'd like to thank her very much indeed for producing it. And the publication date is cited as at 2017, and I'm recording this in the summer. There is the book again. As I said, it's a paperback, you can see there, a bit of detail on the back. Just opening it in the middle, you can see this is the institutional characteristics and judicial culture of what she calls the ECJ. That's what it was called at that time. You can see the structure there. You've got paragraph numbering and you've got footnotes and so forth. A lot of detail. It's actually quite easy to read. I've found one or two European law books to be very difficult to read, frankly. Whether it's lost in the translation, I don't know. But this is actually not a difficult book to read. And what I do like are right at the end, you've got chapter 12, conclusions and recommendations. So it's a very positive, I think, and forward-thinking book. Anyway, thank you very much to Malu Beijer and to everybody involved in producing this book. And I hope you find it as interesting as Elizabeth and I did. Thank you very much. Bye-bye.